All right, we are back again with Doug Rohan of Rohan Law. We are talking about Florida State and the ACC in court yet again yesterday. We're going to give updates on what happened there. If you're not all the way caught up, we have an entire playlist where we have dove into this. We're not going to do a full recap of everything that's happened in this case. If you need that, you can click the playlist above right now. Go watch it. Go get caught up in order and then come back to this video to find out what happened yesterday in court and where we're going from there. All right. So we got a comment about that the other day, Doug. Like, hey, you didn't explain everything. And we'd be on here for 4 hours every day if we tried to combine every video. So, Doug, thank you for taking time to do this. Thank you for jumping on with us. 30,000 foot overview. Yesterday was a win for FSU. You want to give some high level thoughts and then we'll kind of dive deep into some of it?
Yeah, again, thanks for having me on. This is a fun hobby now that's developed for me too. It's something that's enjoyable. The win yesterday in Leon County was not unexpected. It's also not particularly significant yet. We're still figuring out where we are going to have the coin toss. We haven't even had the coin toss to start the game yet. We're still fighting to see if this is going to be a home game or an away game, and that's where we know where this is going to be happening. Love your hat. Shout out to the Irish Noles and going to Ireland. And, that's basically where we are in this litigation. We've got a game coming up, maybe in August, maybe not. We're still fighting about whether it's going to be played in Ireland or whether it's going to be played in North Carolina. But yeah, so FSU won in regards to the Judge Jacobs denying the ACC motion to stay. Now, unlike North Carolina, the hearing yesterday was a little bit more deliberate, a little bit more chaotic, a little bit less organized. I'll take off my Homer hat and say that it was not necessarily an enjoyable proceeding, but that's the style difference between the judges. And so what the judge decided yesterday and ruled from the bench, thankfully, so we have an answer. We didn't have to wait for a decision like we did in North Carolina. The judge denied the ACC's motion to stay the proceeding. We still have two more issues pending, so they punted those till April 22nd, and that's on the issue of the motion to dismiss and the motion to stay discovery. So those two topics were tabled. They're going to take more than 15 minutes of argument, so they were already pushing up against 5 o'clock yesterday, and they just decided they were going to wait on those issues.
This is my not only my Ireland hat, but my lucky hat. So I'm gonna do this for any time I got it yesterday, so I figured that was a good omen. Like anytime they're in court, anytime we have an ACC update, like this is my luck of the Noles hat. So not only for Dublin, but for trying to get out of the conference. Hey, I want to do this too. If you guys hit, we really don't ask for these a ton, but I'm going to this time. If you hit the super thanks button, anything you guys have talked about, like thanking Doug and being thankful that Doug has jumped on here and done this. Any super thanks that we get, I'm going to spend on beer in Ireland for Doug. So anyway, if you want to buy Doug a beer, hit the super thanks. I will be transparent. I'll show you what we make. We'll probably make like $12. But if you want to send Doug a beer, you can do that right now down below. So now Doug's in a much better mood than he was before. Not that you were in a bad mood to start, but that's a good way to start out. So you mentioned this is not the end. This is just the start because we've got April 22nd coming up to rule on those other two items, the motion to dismiss and the motion, the discovery, to proceed with discovery. We'll talk about both of those in just a moment. But can you talk to me just about the different judges, the North Carolina Judge Bledsoe, also Judge Cooper here in Florida?
James kept saying Coach Cooper as well. That was pretty funny. The style is very different. And look, if you're in a dozen courtrooms, you're going to see a dozen different styles from the different judges. Just to take a step outside this FSU ACC litigation and just make a general plug, this is why it's important when you are shopping for an attorney for whatever your legal needs are, you look for the guy that plays golf with the judge on Sunday. Every judge has their different styles. Every judge has their different interests. I buy presents for the secretaries when I can, of the judges for their birthdays, things like that. Drop them some candies because every judge is going to have different style. Now, it doesn't guarantee a win just because I, go to church with this judge or play poker with that judge. That doesn't mean that I'm guaranteed a win, but it means that we know enough about what the judge likes and doesn't like that you improve the likelihood of success. Major League Baseball players scout the pitchers that they're going against. Doesn't mean they're going to hit a home run every time, but you need to know what the tendencies are. And especially since you got to see this one live, and I don't know how many people actually went back and watched the North Carolina video feed that was recorded. It wasn't live, but it was recorded. But you could see the contrast of the two styles of the judges. And I have to admit, I'm glad I'm on the Florida State side. If the North Carolina judge, if Bledsoe had acted and operated the same way Judge Jacobs did in Florida, FSU Twitter would have lost their minds. I mean, it was Homer-ish. It was friendly. One example, just to point to again, these aren't errors, these aren't mistakes, but Judge Cooper let the ACC present their entire side of the case, and then we broke for lunch. That meant the FSU attorneys had an hour to kind of collectively brainstorm their thoughts on what they were going to present after the lunch break. Is that improper? No. Is that home cooking and friendly? I think that was very valuable and very helpful to FSU.
You think they spent that time actually preparing and not just running through the drive-through at Guthrie's
No, definitely not.
for that hour?
I don't even eat usually lunch on trial days. My body kind of shuts down.
Yeah.
You get so stressed and you're so focused on what you're dealing with that you have to eat. I'm supposed to eat. I might have a half avocado or something or a bar, but you're not going to sit there and have a full lunch. So yeah, they spend probably that full hour working on what their afternoon arguments were going to be.
Speaking on the judge specifically yesterday, he was digging a lot into case law, which is a pretty normal practice. But we talked about this off air. It was a lot to do with like patent laws. And what are some of your thoughts on that? Is that good thing, bad thing? Is that potentially troubling, worrisome later on down the road? Let's talk about that specifically.
I think it was a stretch. I don't know that the Court of Appeals will agree or overturn just based on that. But we were talking about the importance of cases being decided based on precedents, or the idea of stare decisis. What has happened before is what's supposed to happen again. Now, there are historical times where courts deviate. That's how we've made great social strides in our Supreme Court when they overturn certain racially motivated, racially biased laws, or make significant changes in our cultural norms. But in general, I, as an attorney, want to know how the judge has previously ruled to advise my clients is what is likely to happen. So you want to find any Judge Cooper decisions on something related. If there's no Judge Cooper decisions on the issue that's related, you look for other Leon County decisions. If there's no other Leon County decisions, then you start looking at what else was in this circuit or the area around Leon County. Several counties are involved in that same circuit. And even then, if you can't find any similar cases, then you can start looking at Florida. Well, that's not uncommon, but it increases the number of cases that are factoring into the judge's decision making process. From there, you have federal courts. Of course, got several districts of federal courts. And then within the federal courts, you have bankruptcy law and patent law and subspecialty. So our judge had some random case recently involving some patent law issues. So it was fresh on his mind, but he started pulling a lot of his decisions and conclusions from patent federal laws. That's a little bit out of left field. So for those people that were critical of the attorneys or wondering why they looked flat-footed, you brief certain cases, you look for those cases that are in opposition to your point of view so you can come up with reasons why they're different. None of these attorneys were looking at federal patent laws to try to make up arguments as to why this should or shouldn't be the case for FSU in this motion.
So I'm going to try and give the judge some. We'll play devil's advocate here, and then we'll go back to why this may be somewhat worrisome. This case is so unique, and the out and left fieldness of federal patent laws certainly exists. But also, do you think that he maybe just didn't have a lot to go on, or like what direction, what other direction? I wonder almost could he have gone?
Well, this is dealing with intellectual property, so it's not completely irrelevant or completely out of the mainstream to look at this from a intellectual property standpoint, of which patent law is a subset. But patent law also has a lot of specific procedural rules that aren't in play in a contract dispute. So that's where the deviation from typical contract law could be problematic. Now, again, you talk about there not being a lot of members suing the conference in prior litigation. We have Maryland and in North Carolina with the ACC, but we don't have a lot of these cases at the reported levels. Remember, not every case gets reported. Every DUI handle at a trial level doesn't get reported. It's only the Court of Appeals and Supreme Court decisions that get reported. So that's what they're pulling their information from. But at the end of the day, other than Maryland and the ACC, and that case law has completely been overturned based on some subsequent North Carolina Supreme Court decisions. There really isn't a lot of history to pull from on these cases.
The most worrisome part of this is, again, you said a Court of Appeals may not overturn just based on this one thing, but there's the idea that if they don't agree with like his reasoning, or they think that it is too far out in left field, it could kind of be trouble for FSU.
Now, keep in mind, again, we're going to learn a whole lot more about appellate law later on if we get to that point. We're only biting off little pieces of the law as they become available and as they become relevant in the context. But there are two types of reviews. There's a de novo review in the appellate court, where the appellate court just throws the entire decision out and starts over from scratch. Those are very rare. What typically happens is a specific question of the law is brought to the appellate court. Did the judge violate some standard? Did the judge violate or misinterpret the law? So, absent a finding that Judge Cooper just completely went off the reservation, the Court of Appeals typically do rubber stamp the lower court decisions. I don't know what the actual statistics are, but I wouldn't be shocked if the Court of Appeals approves a lower court decision 80 to 85% of the time. But what they're fighting over is that 15%, or alternatively, the time that the ACC buys in just dragging this case out further and further. And to that point, FSU, during the hearing, it was made known that FSU appealed the North Carolina decision to the North Carolina Court of Appeals. So I would suspect that after this decision yesterday and the order is finalized, that the ACC is likewise going to appeal to the Florida Court of Appeals.
Would there be any reason for the ACC to wait until after, which we'll talk about April 22nd in a minute, but would there be any reason for them to wait, or will they just appeal this one now and then the other two later, or will they just appeal this one, or what are your thoughts there?
Well, there's a practical question that's involved here, and that goes to the difference in the styles between the North Carolina judge and the Florida judge. When we had the North Carolina hearing, the judge didn't rule from the bench, and the judge went back with his law clerk, spent 10 days, exactly as we expected on Thursday, issued his well-reasoned, detailed order that he himself wrote. The Florida judge took a different approach, wanting to rule from the bench, wanting to make sure that this was finalized at the conclusion of the hearing. But in doing so, if you watch the video, he spent 15, 20, 30 minutes just kind of stream of consciousness talking about what his findings were and why they were. Somebody on the Florida State team, probably a first or second year associate, now has to go through all of his notes. Perhaps they can get a transcript quickly and reduce that entire recitation to some form of formal order. That formal order draft has to go over to the opposing counsel, who then gets to review it and decide, is that really what the judge said or meant to say? And then jointly they issue a proposed order that Judge Cooper is going to sign. I don't know that that's going to happen in less than 10 days or 15 days or 20 days. We may get to April 22nd before we actually have the written and finalized order from yesterday's hearing.
So yesterday's hearing gave us resolution temporarily, because again, it'll probably be appealed, but gave us some resolution on the motion to stay. We still got the motion to dismiss and continuing with discovery as well. So two more items that are up next for Florida State. And again, that just kind of came down to a time situation, just again, with the different styles, with the different day that we had in North Carolina than Tallahassee. We just didn't get through everything. Yesterday, not unexpected, but what are your expectations? And we've got a lot to go between now and then, but for the motion to stay and then also motion to dismiss and then also discovery as well.
So I think the reason why the judge proceeded the way he proceeded is because he already knew he wasn't going to stay this proceeding. He had already done his own research. He had already read the briefs. He did make some statements about, oh, I don't come into this, presuming to already have decided. I don't write a brief or an outline because I want to make sure I'm listening. And I believe him to the extent that he was listening, and he probably had a few specific questions he wanted answers to. But I don't know that anything that was said in that hearing yesterday was going to change the trajectory of where the case was going already. So the decided, Judge Cooper decided that we weren't going to stay the proceeding. And that was the easiest of his decisions to make and most urgent. So that's why he started with that. He hinted at the fact that even though there's a motion to dismiss pending, and he's going to listen to the motion to dismiss, the motion to dismiss standard, as we talked about in North Carolina, is I have to presume everything you said in your pleading is true. And is there enough evidence to move forward? If there is enough evidence to move forward, I'm going to deny your motion to dismiss. FSU really lucked, I wouldn't say lucked out, but met their standard on the North Carolina case for the breach of fiduciary duty because there was no evidence of any fiduciary duty. That's the standard for a motion to dismiss. Everything else was rubber stamped and approved to go forward in North Carolina. Similarly, here in Florida, Judge Jacobs is very likely to rubber stamp and approve the case proceeding without, by dismissing the motion to dismiss, by not granting the motion to dismiss. But he did intimate yesterday, he did suggest that he would be curious about a motion for summary judgment later on. Motion for summary judgment happens after the initial discovery period. So you have an opportunity to exchange information, to exchange documents. Before you present the full trial to a jury, you have a motion for summary judgment, which just says, again, like a motion to dismiss, let's presume that the facts are what the facts are. We now have the facts. So it's not just a pleading, it's not just what's on paper. We have the deposition testimony. This person is going to testify to this. That person is going to testify to that. Here are the documents. Let's put it out all out on the table. And now, judge, you can look at it and say, yeah, there's not a controversy here. So the judge Cooper yesterday was saying these types of issues might be more appropriate for a motion for summary judgment, which is why then he wants to see discovery move forward. So he'll likely deny the motion to dismiss, grant or deny the motion to stay discovery. The case moves forward, and then at some point there will be a motion for summary judgment after discovery closes by the ACC.
So what you're saying is much like against the Florida Gators, the Seminoles will probably go 3-0 this year in Tallahassee to open this thing up.
Which is why, and I love the judge for this part. That's why he talked so much about forum shopping and using that term. We knew that FSU was going to have success in Leon County, which is why the ACC filed their preemptory lawsuit, prospective lawsuit in North Carolina to try to gain a tactical advantage.
There have been questions, there have been thoughts. We have mentioned this several times on the idea of like what happens if both things keep trudging along forward. Will this get removed to federal court? Will you have simultaneous lawsuits that are going on at the same time? There's some controversy around that, some thoughts around that with a 30-day rule. We talked about this a little bit on air, but what are some of your thoughts on that?
So I don't know, and I've been transparent on Twitter to say I don't know what's happening next. Again, I'm not driving this bus. I'm telling you where the bus has been. So I'm learning and figuring these things out as we go along, and then using my skill and abilities to make sure FSU Twitter understands what is happening and why it's happening. I have talked to several attorneys, and there is no consensus on this going to federal court. Some have said that it's not possible, but those individuals haven't told me what the alternative is. Some attorneys have said, yes, there is diversity jurisdiction here because we have two different states concluding in in different ways that these cases need to move forward. And judicial efficiency doesn't call for us wanting to have two, or once South Carolina is involved, three states litigating the same issues. So I don't know how it's going to happen. I don't know how we get there, but I could envision one scenario that 6 months from now, 8 months from now, Judge Bledsoe in North Carolina is sitting down with three complaints in front of him, listening to all three cases in a merged scenario with Clemson Florida State, and perhaps by that point UNC, involved in a lawsuit together in North Carolina business court. The one thing I started doing was researching, okay, procedurally, how does it work to remove cases to federal court? Well, one of the obstacles and one of the reasons why the naysayers are saying that's not possible is because you have 30 days from the time you're served a complaint to request a removal to federal court. If you truly believe there's a diversity issue with this complaint, then you have a 30-day limit. Well, we're well past 30 days in both of these lawsuits. So whether the ACC or FSU wants this in federal court, we've now missed that first window. Now, some things in law are absolute, some things in law are more guidelines. I don't know, and I'll leave that open to somebody else with more information to opine in the comments below. But that's what I'm waiting to see is what's going to happen. Both Court of Appeals are going to have this case. The easiest and simplest solution is that those two courts agree that it should be in North Carolina or Florida. I find that to be unlikely. The next
Yeah.
most likely scenario is we settle. We settle before this becomes an issue. That I think is a higher likelihood. And then the last and most catastrophic approach is let these continue to play out. And I don't know at what point we no longer have two competing lawsuits occurring simultaneously because that's not sustainable.
Yeah. Especially if you then get into two lawsuits in the Clemson case, and then two, which again, if North Carolina, I suppose, merged the three, that they filed, that would be one thing. But I mean, you could have at that point 4 different lawsuits going on at one time, because North Carolina, when they sue, they're going to continue to try and get theirs to. How would that work? Before they even file suit, if North Carolina and the ACC sued each other in the state, would that be a little easier to just merge?
Sure, of course, because they're not having this jurisdiction and venue fight. Then it will go to Judge Bledsoe in North Carolina.
Yeah. So theirs would get merged, but you could still have the Clemson one and the Florida State one, and then obviously the ACCs with however many that gets merged with. So, Doug, I appreciate you for doing this. Anything else high level that you want to hit on before we jump out of here?
No, again, I'm proud of the rhetoric that I've seen. I'm proud of the talks that I've seen on Twitter. It seems like people are engaged and paying attention, and this makes you a better able to educate your friends when you're hanging out at the bar. It's just I know I'm not the only one on here doing this. Several other attorneys are helping educate the public, but just anecdotally, I'm proud to see the discussions and the interactions, because for the most part people are saying the right things. And even when there is a correction that needs to be made, somebody else is making the correction before I ever get around to seeing it on Twitter. So I'm happy for, the way the conversations have gone. I don't know where this is going. There will be a settlement for something between $0 and $572 million sometime between now and 2036. That it'll be curious to see how this shakes out.
Hopefully sooner rather than later. So, although I have enjoyed doing this, but I'd
Mhm.
also like to, we could do some other stuff when we're in another conference. We'll get you back in for some other kind of analysis. So, Doug, tell us about Rohan Law, and then we'll shut it down.
Yeah. Rohan Law, we are in Atlanta and we help you protect your rights. We want to be your best friend on your worst day. And in doing so, we want to make sure that your rights are protected, whether you've been hurt at work or injured in an accident. Rohan Law, we want to make sure that our team here represents you with the same excellence that we've been handling this type of information. I saw somebody say they were so proud about how detailed and good the reporting was for the North Carolina hearing, and with a dozen people in Florida for the Florida State hearing, the coverage was half as good as what I was able to do. And somebody was like, "Well, that's because that's the kind of effort you bring to all your cases and all your clients." And it
Yeah.
made me shed a tear for people to realize that's the case. But yeah, we're real happy and excited to be doing this. I would be digesting and learning this information for myself anyway. So the opportunity to come and share it with you and your viewers is just an additional benefit, an additional bonus.
If you want to buy Doug a beer in Ireland, again, you can hit the super thanks button. If for whatever reason you can't do that, I'll link our PayPal in the comments as well. Make sure that you write Doug or Ireland or something there to let me know what that is. We'll buy Doug some beers for his time and effort and energy in educating all of us. But Doug, I'm looking forward to Ireland, but I'm looking forward to get you back on after the 22nd, after we
Of course.
keep learning. Man, I really appreciate you taking the time to do this.
My pleasure, and I'll save the date.
Awesome. Thanks, buddy.
Take care.